All right, folks, we'll get you back to court in just a moment, but first, still with us, criminal defense attorney, former head prosecutor Bob Bianchi. Bob, I want to go back to what I was talking about in terms of the premeditation. I got the sense you didn't agree with me, but here's my point on that. This whole event, both deaths, were not witnessed by anyone. So who is to say that there wasn't some sort of argument that erupted and then this is what happened? There's also a suggestion by the defendant that he just left the child there as opposed to throwing her or into the river. So you can maybe make the argument that there isn't enough evidence to suggest this was in fact premeditated. The state has other ideas, and they laid out some of the things that leads the jury or should lead the jury to the premeditation. But I think it's an area that I think their case might be weakest if you're thinking about ways to attack it as a defense attorney.
No, I agree with you, Michael. It'd be far from me to disagree with your legal opinion, your excellent legal opinion as always. But and that's probably where they're going to go. I just think that the facts are so overwhelmingly and compellingly against it. And to the point you raised before you raise this point is, if you're going to interpose a defense like that, while you don't have to take the witness stand in this country because you have a constitutional right to remain silent, nevertheless, you haven't presented the evidence to offer the counter argument. So in many cases where we're dealing with passion provocation or some sort of defense like it was an accident, the defendant typically has to take the stand unless they have compelling evidence otherwise, and they don't have that compelling evidence here. Can they argue for the lesser offense? Sure, but that's why the prosecutor was making such a point of saying that premeditation can be performed in a flash, in a moment, and rather she's saying not only did it not happen in a flash or a moment, but that rather it was actually premeditated, planned and plotted for a significant period of time. So I just don't see the counterbalance. I agree with your principle legally. I just don't see the factual counterbalance presented in this case.
Fair enough. And I wanted to ask you also, before we head back to court, what your experience has been with coerced confessions. We saw the defense, they brought on one witness to talk about this Reed technique and the different ways that someone can be coerced into confessing to something or to facts that are not necessarily true. What has been your experience with that?
You know, Michael, my experience has changed and morphed over time. In the beginning, I think when I was less mature as a trial lawyer, maybe as a human being, I would figure, like, who would ever confess to something they didn't do? And as time went on, I have come to believe this to be true. There are a statistical percentage alarming enough where, and this is why in many jurisdictions, maybe this state too, but in Jersey, you cannot convict solely on a confession. You need a confession and some corroborating evidence. So it is an issue that should be addressed.